this matter?
Correct, Your Honor. My understanding is that Mr. Weatherspoon will waive his right to a preliminary examination. The people will not file a habitual in this matter. And in circuit court, there'd be an offer for a plea to an added count of possession of less than 25 grams of controlled substance.
We've got a problem. Mr. Allen. You have his bond violation?
I do. So, well, can I address it on the record, Your Honor?
Yeah, go ahead.
I talked to my client about it. His position is that he was incarcerated. You know, I think he admitted the first violation, to Your Honor. He denies this one, and he's paid, I believe it was $150 for the sample to be retested at a lab. So, given that the retesting is in progress, I'd ask the court to defer any action to Judge Conlon, and perhaps we'd have those test results back in 2 weeks, or I mean, if they came back later than that, I'm sure the government would be addressing it regardless.
Does he have a medical marijuana card?
No, I mean, I don't, that was why I had the, last time I asked you, I told you about the appointment, and that was the whole thing. So we trying to get a medical marijuana card right now. I got a doctor appointment scheduled on February 11th for all of this. In the cocaine drop, I don't see how it was positive, and I'm supposed to test today too, actually. So I'm trying to figure out how. I don't understand how was it dirty. That's why I paid for it to get tested again. They told me it'd take up to 2 weeks for it to come back from California, and regards to.
Well, maybe if that's the case, I mean, except that, and here's the problem, counsel, I might wait, except that his last 3 tests have been positive for cocaine spanning from November 17th to December 26th. And then he had the THC positive in November, but then THC leaves his system, and then he's back with THC in his system again.
I speak, Your Honor.
All right. If your attorney wants you to, I mean,
Don't talk about anything before November, but I think we're fine talking to the court about his substance abuse issues. He's pretty open with it. You know, he admits he has an issue. I'd just say to the court, I think THC opinions have evolved, and you know, I haven't known Mr. Weatherspoon very long, but he's pretty obviously in pain to me. Frankly, I think THC is better for a person than taking opiate pain relievers. He can barely walk. I mean, I think he needs.
That's good, doctor. I don't know.
He had a doctor appointment.
Made that issue. That's not it. And it may very well be, but that's why he needs to just get a card, and then there isn't an issue.
I scheduled to make an appointment for the card. In the cocaine dirty, that's why the first time I told you, I said, Judge Simpson, I did that. This time I'm 100% sure I didn't do any drugs. So that's why I had it sent out for the test, because I know I can't be dirty for it. Would you allow me to take a test today to, like, I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
Just come judge is good.
And if it comes back dirty, I just leave you in there forever.
Ever is a long time.
I know, but we're gonna make a deal. Let's make a deal.
Let's make a deal.
Is that it?
Deal.
If you come back clean, then I get to decide what to do. Test. Let him know he's coming over to test.
Where's he going? To community corrections?
Community corrections.
All right. Obviously, if you come back, work out. So, come back
Court calls the case of the People versus Martinez Smith.
Good afternoon, Your Honor, Raymond Cook with the People.
Good afternoon, man. Please, court, Kareem Johnson, appearing on behalf of Ms. Smith, who is approaching, standing to my immediate right.
Your name?
Martina Smith.
All right. I have before me a plea form. Plea form indicates that the defendant is going to be pleading to count 3, attempted resisting and obstructing an officer. That's a guilty plea, the 1-year offense. On her successful plea, counts 1 and 2 would be dismissed. And there's a sentence agreement of sentencing under HIDA. That's the court's full understanding.
That's correct, Your Honor.
Let's have her sworn.
Raise your right hand. Solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing so help you God.
Yes.
State your name, please.
Martina Smith.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer.
Yeah.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that? You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge pardon? Valvo or her successor in the 15th District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights? Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Yes.
On the date of July 28th, 2025, at the location of 3205 Boardwalk, City of Ann Arbor, Washington County, State of Michigan, did you come into contact with officers from the Ann Arbor Police Department?
Yes.
And you'd admit they were in the lawful performance of their duties?
Yes.
How do you think you resisted and or obstructed them?
I didn't firmly put my arm behind my back.
Pardon?
I didn't firmly put my arm behind my back. Strangled.
Okay, so they were trying to arrest you
Yes.
and they told you to put your arms behind your back
Yes.
and you resisted doing that.
Yes.
All right. Young lady, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Nothing, People.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea. Guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 20th at 9 a.m. before Judge Bello.
January 20th, 2026, 9 a.m. before Judge Valvo or her successor. Will continue. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, sir. Is that it for Mr. Johnson?
It is.
It is. Mr. Johnson, have a great New Year, sir.
Thank you too, Your Honor.
We'll answer from either side on what's happening on this one. This is holding. It is.
Oh,
Yeah, this is Katie.
oh, so we don't know.
This is Katie. That was Mr. Miller.
Okay. Oh, got it. Okay, you'll get that. This is,
That is Ms. Rosmierski and Mr. Miller.
you know what we're doing on Riddle?
We're standing before the court unable to proceed.
I was waiting to see if the people had a witness, Your Honor.
We do not have a witness.
So it's amazing what conversation and talk will do. I'm just saying. Why don't I call that case?
Thank you.
It's your job easy today. I did. Because that's what my obligation in life is. Court does call the case. People versus William Riddle.
Katie Wisniewski for the.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Riddle, who approaches the podium. Please state your name.
William Michael Riddle.
Thank you.
Notice court is aware this time and date scheduled for preliminary examination. The people are unable to proceed this afternoon.
Your Honor,
Go ahead.
in light of the people's position, we would move for dismissal without prejudice.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Right?
Thank you, Your Honor.
Thank you.
And Your Honor, Happy New Year to you and your staff. And I failed to say it the last time. I hope everybody had a very Merry Christmas.
Absolutely.
We were a little
did.
more pressed last time for time. Thank you, Your Honor.
I did because I stole all Alan's presents. So I had a great Christmas. So the other one is a hold.
Yep.
And Ms. Williamson's not in. I'm gonna step off for a little bit and then come back. And I need this. Pardon?
She's ready and available.
She is ready and available. Oh, okay, that's fine. I'm just gonna step off because I have to take a breath for a minute.
An exam, Judge, we're gonna waive that examination. My client understands that he has a right to a preliminary examination, and that if an examination was held, the people would have to show that a crime was committed and that he probably committed that crime. He wishes to waive those rights.
I did discuss this with defense counsel, and we discussed that I would be filing an amended information with the corrected counts. May I approach with that information?
That is correct, Judge.
So
So we would be waiving as to counts 2 and 3, and count 1 would be dismissed. Counts 2 and 3 are child sexual abuse of material and aggravated possession, the 10-year felony.
okay.
20-year felony is being
So he's the original charge. Let me go.
with 75145C2, which is a 20-year felony, Judge.
I got that.
Oh, okay.
So I'm just going on the count. So count 1 is going to be dismissed. He's waiving up on counts 2 and 3.
That's correct, Your Honor.
All right.
That is correct.
You understand that, young man?
Speak up. Yes.
All right. And you understand that you're waiving your right to a preliminary examination where the people would have to show by the standard of probable cause that these offenses were committed and that you committed them.
Yes.
Okay. And you understand you're not going to have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Your Honor, as to the matter of bond,
Oh, hold on a second. Preliminary examination having been waived, defendant is bound over to circuit court on counts 2 and 3. Count 1 is dismissed. Yes, go ahead as to bond, but as to the circuit court arraignment, you waive formal reading of the complaint
yes, Judge.
or the information. Stand mute at this time.
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
January 15th at 1:30 with Judge Slay.
January 15th, 2026, 1:30 before Judge Slay. Yes, as to bond.
Your Honor, as to the bond, I believe that the bond is really excessive. It's $500,000, based upon the amended charge, which is basically half of what he was facing. I believe an appropriate bond, and also my client has no prior criminal history whatsoever. I would respectfully ask the court to place a more reasonable bond considering the circumstances. I believe, I'm not asking for a personal bond, Judge. I respectfully ask the court to give him a bond, possibly $25,000, 10%. 500,000, I believe, is really accessible. I don't know if the court remembers. I've probably had 1,000 other cases since I last
No, I
argument.
remember you,
Oh, okay.
and maybe that's a good thing or a bad thing, but I
Yeah.
remember.
Well, I was hesitant because I gotta catch a plane tomorrow. I don't want to get locked up today, so otherwise I wouldn't mind, but
And maybe they'll hold the plane for you if you keep on.
May I?
Yes.
I would object to a change of bond. I did, Detective Morrison from Washington County is the officer in charge of this case, and I did speak with her today. She did a review of Mr. Allen Gaffney's phone, and both in the report and in my conversation with her said that he had an overwhelming amount of child sexually abusive material on his phone. And it was accessible by her, not a forensic analyst. Just in reviewing his phone, he had an overwhelming amount of both images and videos, and prepubescent children. I think given that this bond is appropriate.
yeah, I'm not going to go
Go ahead.
into everything that I said before. He was in a relationship with an individual. This individual, yeah, I believe that given the circumstances and the bond is just really excessive. I don't want to get into the other underlying facts about, and the people know that this other person that was the target of this investigation is the main character in this situation.
Let me ask this. And I understand that there have been a change in charges. I also know that sometimes when that happens, when there's a waiver up, it's a waiver up on 2. But given what would be this overwhelming amount of stuff, and again, I don't know what that is or necessarily quantifiably means, could there be potential other charges?
I mean, certainly.
I mean, I'm not suggesting it. I'm just trying to get a feel
I
for
think
it.
it was
Yeah.
not, in my viewpoint, charged correctly at the outset. And so part of this was to ensure that he was waiving up on the correct charges. But yes, I mean, he's waiving up on counts 2 and 3, but technically every image or photo or video that he had could be another charge. So the answer is yes. As to like a different charge, I at this time don't think so. This did originate as a Canton investigation into, yes, correctly, a wider ring of people of which the defendant was part of. And he was residing in Ypsilanti, so that's why this case is.
And just briefly, Judge, the person that he was involved with that originated in Canton, those individuals were referred to the federal system and they were prosecuted in that realm. He is the only one that was not, and that is because he was not, in their opinion, a main character in this.
When you say they're the federal.
Correct.
Okay.
Correct, Judge. So, and I'll get into this when it gets to circuit court, but in relationship to them being on his phone, this other individual that got charged.
As arguments intensify, the courtroom shifts to one critical issue: bond. The defense argues the amount is excessive, citing no criminal history. The prosecution pushes back, citing the severity of the allegations. After hearing both sides, the court reduces the bond, but not nearly as much as requested. The message is clear. This is serious, and release will not come easy. This decision balances public safety with due process, and it sets the tone moving forward. Now we ask you, was this bond reduction fair, or should it have stayed even higher? Share your opinion below, and make sure you like, share, and subscribe for more courtroom breakdowns.